Hi, I'm Steve Murphy, and this is the Insider Exclusive. Today we go inside the world of investors in justice right here in our American court system. Stay tuned to see how 3,000 investors and their $600 million are being denied justice. From 1989 to 1996, 3,000 investors invested more than $800 million in a company called USA Mortgage. And they stand to lose that money today. And today I have with me Donna Cangelosi, who is the head of an investors group, and her appellate attorney, Bill Cohan. Welcome to the show.
Thank you.
Donna, this is a long, convoluted story. But start from the beginning, explain to our audience, exactly what's going on here.
Well, our story started just about 3 years ago on April 13th, 2006, when the mortgage originator, who was basically placing mortgages on behalf of 3,000 direct lenders, as we call ourselves, went into bankruptcy. At that particular point in time, we were puzzled as to how a mortgage originator could go into bankruptcy. But ultimately, as the bankruptcy proceeded, we found out that there was a variety of different nefarious activities that had occurred.
Right, and let me stop you here for a second, because I want to correct one thing. It was from 1989 through 2006.
That's correct.
That 3,000 elderly people invested.
Yes.
You were one of those investors.
I was one of those investors, and as a matter of fact, I was responsible for not only bringing my own money into it, but I had such good experience with USA Capital that I brought many friends and relatives into this.
And they were a company that had been in business for, what, 20 years?
Since at the point that I had invested, they had been in business for 13 years.
Okay, and they had a stellar record.
Stellar record.
They paid, people bought trustees, right? They got paid the interest, they got paid their principal back, so that was a big reason, that was an important reason why people invested.
It was a very important reason. There was no blemishes against their record.
So USA Commercial Mortgage goes bankrupt.
They went bankrupt.
Okay, now what happens?
So what happened was we had a trustee put on us, or actually there was a trustee that was brought in as part of the bankruptcy. It was already prearranged in USA Commercial Mortgage. We went into bankruptcy court, and as the bankruptcy started unfolding, we found out that there was all sorts of, as I said, nefarious activities that had occurred. Loans
by whom?
By USA Commercial Mortgage principals, who had now been removed by the trustee.
Right.
Loans had been underfunded, even though the money had been collected. Loans that had been repaid had been used, instead of to pay back the original investors, had been used to pay out interest payments on defaulted loans that were non-performing.
Now, this sounds kind of like a Ponzi scheme.
It was a back-end Ponzi-like scheme, but in the beginning, all of our names went on trust deeds. And there could be, on an average trust deed, USA Commercial Mortgage was an aggregator.
Right.
And so there could be 150 strangers, direct lender strangers, that put in anywhere between $50,000 and $50,000 on up on a specific project. We had about 100 loans.
Right, and they lent it actually to USA Commercial Mortgage, which in turn loaned the money out to developers.
Well,
right?
What we did is they acted as a broker. Our money went into a trust account, and then they would close the loan, and then we would get a trust deed back. We had a deed of trust and a promissory.
And that's important to bring out, because as investors, you didn't buy stock, you didn't buy, bonds. You were actually on the deed, weren't you?
That's correct. Our name was on the deed of trust. So we were a secured investor.
Now
That's why they were called direct lenders, Steve.
Right.
Because they actually gave the money to USA Capital to loan to people who were doing real estate projects. And after the loan was made as part of the process, each of the direct lenders had a mortgage representing the amount they had loaned. So they thought if there were a problem with non-payment of the loan, they as direct lenders could foreclose on the property and take it over and manage it and protect their investment. But during this bankruptcy, some other things happened. Please continue, Donna.
So what happened is, as we proceeded into the bankruptcy, we had this huge parade of professionals that came into this bankruptcy. My own personal opinion is I think in 2006, the bankruptcy business was very slow. So therefore, because the economy was booming. So therefore, we had this huge parade of professionals coming in and creating...
Approved by the court.
Approved by the court, creating this massive amount of fees. Just absolutely massive amount of fees.
I think it was 40 million.
We ended up with $40 million in bankruptcy fees and professional fees against a company that actually had only $10 million of assets. USA Commercial Mortgage only assets was in originating and brokering loans. They had no other assets.
So kind of in a way, they had a lot of trust deeds under their control, correct?
That's correct.
Kind of in a way, they knew they didn't have enough money to pay them, so now they're looking at an asset to pay them. And the assets are owned by the direct lenders. You guys, 3,000 investors, right?
That's correct.
What happens next?
So they came up with a scheme by which if you had stolen principal and you also had money that was paid out to you to cover up that stolen principal for what they call an interest payment, a regularly scheduled interest payment against your loan, they called that prepaid interest. We had to return back the prepaid interest into the bankruptcy estate, and they made that an asset of the estate. There was about $40 million in prepaid interest that was going to come back into the estate from the direct lenders that were basically those payments were used to defraud the direct lenders.
Bingo, they got their money.
That's right. It was used to defraud the direct lenders because the USA Commercial Mortgage principals did not want to come forward and say, hey, we have non-performing loans here.
This is called robbing Peter to pay Paul.
Yeah, but by the court system. This is all happening under the supervision of the bankruptcy trustee, correct?
It's all happening under the supervision of the U.S. trustee, the bankruptcy trustee, and the bankruptcy judge. So what happened was there was 3 plans, bankruptcy plans, that were put in place.
And this, by the way, what year is this happening?
This is still in 2000. This is now 2006 still. Okay. There was 3 bankruptcy plans that were put in place. Each one got worse for the direct lenders. And by the 3rd bankruptcy plan, which basically took the prepaid interest from one pocket and put it into the estate and kept it for the professional fees, and we got nothing back in the other pocket, that was when I came forward and started objecting.
And this was in 2006?
Still 2006. It was
So in other words, the court is not recognizing that you are actually the trustee holders, correct?
That's correct.
And they're just totally ignoring that. They're paying the professionals, by the way, they're paying the professionals to do what? What are these fees for?
Well, we had about $12 million in forensic accounting, whereby they did cash tracing for every single loan payment coming in and every single loan payment going out.
Yeah.
So there was about $12 million in accounting, and there was just runaway professional fees.
Okay.
All of the professional fees were unchecked. At every single hearing, we would probably have no less than 20 attorneys
Let me
at
suggest,
$400 to $500 an hour or more.
if I may respond to your question, there were some real problems that had to be solved. In other words, the money that had been robbed from Peter to pay Paul had to be traced, and that required a lot of accounting to figure out where it came from, to send it to people to whom it was entitled. And then there were legal issues. But Ms. Cangelosi clearly identified some terrible abuse that the bankruptcy court allowed to take place at the expense of the direct lenders.
Now, when you say you came into the picture, what did you do?
I had been already communicating with many people because of I felt responsible. I had essentially brought in, tens of millions of dollars of investment through my experience into USA Commercial Mortgage, and I felt responsible. So what had happened is I had been going to the bankruptcy proceedings, and I had been communicating, putting out a little email communication with other direct lenders who I had been connected with. This was a networking type of business where if you invested and you had a good experience, you told me, I told Bill, and then before we knew it, a network grew. So through this communication chain that I had set up early on in the bankruptcy, very early on in the bankruptcy, I was now probably communicating with 600 investors, people I didn't know, I had never known. What happened was when we saw the bankruptcy plan change significantly, that all of a sudden took our interest payments that had been made against to defraud us against non-performing loans, and it was taken, and it was supposed to be paid to us back for our stolen principal. I had $180,000 in stolen principal, and instead of that money coming over to me and being offset, if you will, it was going into the USA Commercial Estate so the professionals could have at it, and I was going to end up with zero. I started organizing a group to raise a legal fund in order to be able to fight that.
And the name of this group?
The name of the group was called the Lenders Protection Group.
Okay.
But what Donna did that she hasn't told you specifically is that she organized people to look after each loan. Just to remember now, we had, by this time, by later on in 2006, there were roughly 70 different pieces of property on which different groups of direct lenders had loaned money. So each one of those loans had separate issues with respect to that loan. The non-payment, the late payment, the diversion of funds, the accounting that needed to be done, some of which was simpler when you only had maybe 25 or 30 people loaning, as opposed to a loan where maybe 200 people had loaned money on a bigger project. Donna got the communication set up for every one of those projects, and she also made arrangements to turn these groups of people into organized entities called limited liability companies.
And you did that for protection?
That was subsequently down the road, yes.
You did that for protection?
We did that
so
for protection.
Their ultimate maximum loss would only be the investment that they had?
That's correct. Because at that particular point in time, well, ultimately, when we set up the limited liability companies, we were concerned over two things. We were concerned over the future actions that happened to us after the bankruptcy closed. And we were also concerned over lender liability lawsuits.
Yes.
Because we had loans that were short funded. As a matter of fact, you'll speak with a borrower today who will tell you the story.
Okay, now, it went from bankruptcy court to the federal court it's in right now, correct?
That's correct.
What was the transition there?
Well, what happened was the bankruptcy plan, part of the assets of USA Commercial Mortgaging was the loan servicing of these portfolio of loans. Lenders had a loan servicing agreement with USA Commercial Mortgage, and that loan servicing agreement was considered an asset of the bankruptcy. The bankruptcy decided in order to raise more money that they would sell the loan servicing rights to that particular portfolio of loans.
And let me explain that what the loan servicing meant was that USA Capital was supposed to collect the payments every month and then distribute those payments to the direct lenders, for which they received anywhere from 1% to 4% of the amount collected. Well, if you take $800 million and you're getting payments on that, and let's say it's $8 million a year, then 1% of that would be $80,000. Well, what happened was the bidder got the right to service the loans. But the direct lenders had the legal right to say, we don't want you servicing our loans. This is where the dispute became a catastrophe in district court.
Right. Bankruptcy court approves the sale of the servicing element of USA Commercial Mortgage, right?
Exactly.
That's correct.
It is sold to whom?
It's sold to first off, let me explain to you, the servicing of commercial mortgage loans is a highly specialized business.
Okay.
It's rated, it's tracked and rated by premier organizations such as Standard & Poor's and Fitch, and they rate loan servicers. Rather than bringing in a rated loan servicer for already people who have been financially devastated and giving them pros, what they do is they bring in a company called Compass Financial Partners, which was an assetless shell set up basically a month before the bankruptcy auction by two partners, Len Mezzi and Jake Cohan. It was set up for the intent purpose of buying these assets. Compass Financial Partners, as I said, this unrated, no experience, assetless shell.
Yeah, usually in these situations, the bankruptcy trustee is the one who recommends something to the judge.
That's correct.
And that's what probably happened, and the judge approved it.
The judge approved it. However, on the eve, what was interesting in this, Steve, is on the eve of the auction, the asset purchase agreement, which we had approved, changed dramatically without disclosure to the lenders. So what happened was and when we raised that issue at the bankruptcy auction in court, we were told by the judge to sit down and shut up.
You were told by the bankruptcy judge?
By the bankruptcy judge to sit down and shut up. We said, Your Honor, we feel that these terms that it's being changed to is egregious to the direct lenders. We raise our concerns, and
What did she say exactly?
She basically said, please sit down and be quiet. If you want to raise your concerns, do so in an appeal.
Okay, and her name was?
Judge Linda Regal.
Okay, now, it gets sold, the servicing element gets sold to Compass.
Compass.
Okay, the bankruptcy closes.
Correct.
Okay, now how does it end up in federal court?
Okay, it ends up in federal court that prior to the closing of the bankruptcy, or prior to the auction, I had a call from, if you will, a whistleblower, who was a former, not employee, but he was a former consultant to Compass and had helped evaluate the portfolio. He called me, and his first words to me are, you guys are going to get screwed.
Okay.
And I said, why? He said, because Compass Partners is going to buy this portfolio, and their plan is to take fees that the loans generate that are granted in our loan servicing agreement as incentive compensation to quickly collect defaulted loans. They're going to take these fees, and their position is that whether they're collected from the borrower or they're collected from you, they're going to get these fees.
How did it get in federal court?
The legal dispute was whether the loan servicer, the successor who bought Compass in this case, could collect the default and late fees from the direct lender's portion of this loan. And the loan servicing agreements do not provide for that.
So
they provide that Compass, or USA Capital, its predecessor, could only collect late and default fees from the borrowers who are late. The problem is, of course, that the real estate market began to decline, so there weren't going to be any fees collected from the borrowers. They were in default.
Right.
The issue was whether and to what degree the direct lenders could get all of their principal or most of their principal and not even get the interest that they were hoping to get in many cases. But what the purchasers, Compass, and really the people who funded it are Sylar advisors, and this is the essence of the dispute in federal court, took the position that, oh no, we could take late fees and default fees right out of the principals loaned by the direct lenders and take all of the money the longer it was in default. And so they not only had no incentive to clean up this mess and get these direct lenders as much money as possible, as quickly as possible. The more it was dragged out, the longer it took, the more they said they could claim to take away from the direct lenders who were owed their principal back.
So you as a group went into federal court.
We went into federal court.
Sued Compass.
Correct.
Actually, the LLCs,
Yeah.
which had acquired the interests of most of the direct lenders who pooled their resources on each one of these loans, the LLCs came in, and the LLCs filed suit, which leads to one of the big problems that happened in federal court.
Interesting enough, we're going to have some of these investors on this show today. My next guest and another investor is Dr. Chuck Ayub. Welcome to the show.
Thank you.
Unfortunately, we have people sometimes on the show lost a great deal of money, and it seems like you have lost money with this mortgage company.
Yes.
You're an educated man. You know, what did you see in the USA Mortgage? What did you see?
Well, I knew that some of these trust deeds were kind of shaky, and I'd been involved in other companies, so I had my attorney go to the state and check them out. They gave him a great rating.
Yeah.
He checked with other companies in the area, and they said this company's solid as a rock.
So you invested how much money?
$175,000 in 2 loans.
Now, you felt secure because you had trust deeds on real property.
First trust. I didn't care if USA folded and went away.
Because you had the property.
I had I got the escrow papers. I owned the property.
Now, here comes the travesty of justice here. It ends up in a bankruptcy court, then in a federal court, where the federal judge, the district court judge Jones, really doesn't give a rat's ass about your
and she said
trust
that.
deed, right?
And she absolutely said that.
They don't
Too
care
bad.
about you. What do
Too
you
bad.
think about the court system?
I think, I can't believe in the United States it's my money. I own the property. How can you take that away without a court action?
Yeah.
She has no right to do what she's done. It's unbelievable.
Well, hopefully, Bill and Donna are going to rectify this in the Ninth Circuit, and we wish you the most and the best success. One more investor in this nightmare is a former airline pilot, worked for Northwest Airlines, Don Hess. Welcome to the show.
Thank you.
How much money did you invest?
About 200,000.
200,000. And when you invested it, you felt it was secure.
Oh,
You
absolutely.
were getting a trust deed, correct?
Absolutely.
On real
and
property.
And it worked for 4 years.
Yeah.
I invested from 2002 to 2006. And the initial part of that time, I was receiving nice amounts of interest, and I expected that to continue.
So out of the 200,000, how much did you get back?
So far, 75. So I still got
75. So you're out, well, you're out the principal, and the interest, helps a little bit. This has not only been a problem, with the company, USA Commercial Mortgage, but also it's been a problem in the court system, hasn't it?
Oh, absolutely.
What's your opinion? Most Americans think they can go to court, they can have their day in court. Is that happening in Las Vegas?
We haven't had our day in court yet.
Well, what's happened so far?
It's now been 3 years.
3 years. But I mean, so far, the Judge Jones, has not even really cared about what the investors or the trust deed holders invest in, did he?
It sure doesn't seem that way. All his decisions seem to be made in favor of the defendants instead of our interest. And he seems to coach through his temporary rulings. He seems to coach them in a direction that will allow them to continue to prevail over us.
Not even caring about good, hard-working people like yourself.
Not at all.
Okay.
And particularly those who have invested a lifetime's savings and
Yes.
who had anticipated a retirement on those savings.
Yes. Well, I'm sorry to hear all this, and hopefully Donna and Bill will rectify this matter and get you a better judge who can listen to you folks.
Well, I'm hoping to help in that effort.
Thanks for coming here. I have another investor, Gail Gray. Welcome to the show.
Nice to meet you.
Gail, you're a CPA.
Yes.
You know books, and you know numbers, and you know good investments when you see them, right?
I thought I did.
Yeah, and what happened with USA Commercial Mortgage? It went bankrupt?
USA went bankrupt in a surprise to me.
Yeah.
I had invested in it for about a year and a half. I went into it with high recommendations from my father.
You invested about a year and a half ago.
About
How
a
much
year and a
money
half
did you
ago.
invest?
I invested $190,000
Wow.
in, invested $50,000 at first. The loan did everything it was supposed to do. It paid me back, paid me my interest. I got my principal back, so I went into another one.
Right. As a CPA, you look cautiously at all investments, don't you? This company had a great record, I think 13 years,
Yeah.
of paying people, doing the right thing. But I think from, let's say, my point of view, I would feel comfortable if I knew that my name was on the deed, right?
Absolutely.
And your name was on the deed, right?
I,
You were direct
every
lenders.
time I got my paperwork, I checked to make
Yeah.
sure my name was on there.
So what do you think, what is your opinion of what the court system is doing to the direct lenders, the people who are trust deed holders? What is your, tell our audience how you feel about this.
I have to say I've lost complete confidence in our legal system. You know, when you invest in something that has a first trust deed and you're on title, we had no business in that bankruptcy. When USA went into bankruptcy, I was confident we were going to be okay.
Yeah.
You know, I thought, I've got a first trust deed.
Yeah.
And to watch over and over and over again the injustice,
Yeah.
the decisions that have been handed down have been appalling.
Yeah.
You know, it just floored me.
I'm very fortunate to have my next guest, Chuck Meriden.
Nice to meet you.
Thanks for being on the show. You're another investor in this sad situation, and I understand that you were actually in the mortgage business, weren't you?
I was. I
For,
spent,
what, 25 years?
20 years roughly in the mortgage business.
So you know about these kind of investments.
Exactly.
Have you ever seen a situation where people have their name on a trust deed, they're direct lenders, the property secures their investment? Have you ever seen a situation where the court just ignores that and wipes them out?
You know, I did a lot of due diligence before I invested in this. I actually drug relatives and friends into this. When you loan money at a loan to value that you perceive to be a safe loan to value, you would never perceive the fact that something like this could happen. USA Capital goes bankrupt, so what? I'm secured by a deed of trust.
Right.
But now the court system has caused this to drag out over 3 years now, which during this period of time, the values of the collateral has depreciated
Yes.
tremendously, and it's left the direct lenders just in a real pickle.
I'm very pleased to have with us one more investor, thank you very much for being on the show. Elizabeth Murphy, right?
Yes.
You know what they say about Murphy's Law, don't you?
Yes.
Okay. You invested in USA Capital.
Yes.
You lost, what, 25,000?
Yes, that's correct.
And how long ago did you invest, by the way?
I invested 2006.
Okay. You invested
Yeah.
because you were referred to it?
Yes, I
You were.
was. A friend of mine told me about it. He checked it out. He said this would be good for your retirement. And
Yeah.
I said, okay.
The interesting thing about this investment is you were secured by a trust deed on real property. You were a direct lender, weren't you?
Yes.
And so you felt like when the USA Mortgage Servicing Company went bankrupt that you were protected because you had a trust deed on the property.
That's correct.
But that didn't turn out to be true, did it?
No.
Because the judge has totally ignored all the investors, hasn't he?
Yes, he has.
What do you
Yes.
think about our legal system because of that?
I'm very, very disappointed in the legal system.
Mm-hmm.
I'm disappointed in the judges. I always thought the legal system was fair, the judicial system was fair.
Yeah.
I thought that since we are the victims, the judge would see that.
Yeah.
They don't see it as that.
Well,
We-
hopefully, through the efforts of Donna and Bill and the other lawyers, this will be changed in the Ninth Circuit and we'll get a more favorable judge who can do the right thing, right?
Yes, we hope so.
This is a travesty of justice, and these people that we have just witnessed, you know, they put their heart and their soul, they believed in this. The judge has basically knocked their feet right underneath them. Bill, where do you go here?
We're in the Court of Appeals seeking relief from the appellate court to reverse what the judge has done and get us a judge who can hear and adjudicate the issues that should have been decided 2 years ago. Namely, who is entitled to what and in what order, rather than trying to crush these people, primarily their spokesperson, Donna, to prevent them from even asserting their rights. If we're successful in the Court of Appeals, we will get a chance to actually litigate these disputes and the claims these direct lenders have to get their principal back and to sue the people that have ripped them off.
Well, we wish you much success. And Bill, how can folks get a hold of you?
Well, they can call my office at area code 858-832-1632.
Do you have a website?
I do. It's www.williamacohan.com.
And that's Cohan, C-O-H-A-N.
Yeah,
Okay,
correct.
.com. And Donna and Bill, thank you for being on the show, and we wish you much success.
Thank you, Steve.
Thank you. Thank you for watching. You can get more information about our guest and the issues at insiderexclusive.tv. Come back again.